Welcome back to Courtroom Chronicles, where justice meets drama and every verdict tells a story. Today's case. A seemingly simple furniture dispute that spiraled into a full-blown legal storm. We're diving into a battle between a frustrated customer and one of the biggest furniture retailers in the country. On the surface, it's about a $1,700 default judgment, but underneath, it's a story of missed hearings, courtroom tension, and a judge losing patience. Stick around, because this case will have you asking, can a company really pay twice for the same furniture? Let's find out.
Declined to grant, and so the motion, the judgment stands, and that was on April. In order to set aside a default, in fact, it's not even exactly clear whether you can even do it in small claims court, but at a hearing, you have to show a legitimate defense and good cause for not appearing. I didn't find any good cause for not appearing. So the plaintiff then did a subpoena to discover the ability to pay on this debt, and nobody appeared from the furniture for that. So we set a show cause hearing regarding this. So, Mr. Kloppenstein, thank you for being here. Ms. Manley, you as well. Mr. Kloppenstein, will you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You so far have got about $10 zillion worth of bad publicity out of this case. I found on her behalf by default in the amount of $1,669.17. 62.28 for a total of $1,735.42. She wanted to add some other items, but they weren't part of the original complaint, so I wouldn't allow them to be added. You moved to set it aside. I denied the motion to set it aside. She did a subpoena to collect. She wants her money. You may feel that she was already made whole. She got the furniture returned plus other stuff. But this judgment entered by default. So the ship has sailed. You owe that.
Right here, the judge is explaining one of the most misunderstood legal outcomes, a default judgment. When you don't show up to court, even if you have a legitimate defense, the court can automatically rule against you. It's like forfeiting a game before kickoff. Ashley Furniture missed their day in court, not once, but multiple times, and that mistake cost them over $1,700. This is the part where legal responsibility meets reality. No matter how valid your side is, if you're absent, you lose. It's procedural justice at its coldest.
I was out of the country. I did not know about it, but we thought it was made whole by exchanging the piece.
I understand.
We thought it was made whole.
It wasn't. And I didn't like entering the default. I thought she got paid twice. I thought she got made whole plus she got $1,600.
Yeah.
But you got notice. There was a hearing. She was here. Nobody showed up, and a default entered. So yes, you got arguably double dipped, but you owe this money because you didn't show up. We're not going to revisit your defense. You weren't here to raise your defense. Then I had a hearing to set aside the default, which I'm not even sure I can do in small claims court. And I didn't set it aside. Now she wants her money. And then there was a subpoena, and you didn't show up for that. I'm trying to determine when that was. We did move it.
We moved it, yeah.
If you were to be here on.
You can hear it in the judge's tone, he's had enough. After multiple no-shows, he's clearly fed up with what he calls, too much bad publicity. It's a subtle jab at the company's reputation taking a hit because of a small claims fiasco. Imagine spending hours in court over lawn furniture while corporate lawyers shuffle papers. The message here? Judges, remember when you waste court time. And in this courtroom, patience has officially run out.
don't remember a subpoena for discovery. It's an order to show cause why you should not be in contempt, but I don't see that you missed anything to be in contempt.
I'm sorry.
Yes.
I had to pay the St. Joe County of Mishawaka to have Ashley's furniture served.
I'm trying to figure out what date that was. I'm looking and it's not in the paper file in front of me.
And then he didn't show up.
Yes, I'm trying to determine what date that was.
I filed, oh wait, let me make sure.
Here's the subpoena. Subpoena was for him to appear on August 11th. And he did not appear. That's why you're in contempt. You got served the problem is you're too busy. You don't show up for stuff. So
I'm also out of Fort Wayne, not, we have a store in Mishawaka, but
yes,
maybe that's what was served. I am out of Fort Wayne.
let's see where the proof of service is. Picked up the plaintiff to have personally served on the defendant. Service of subpoena. It was served allegedly by a sheriff's deputy for St. Joseph County, which would be South Bend. Cost her $88 additional. Well, they served it on Ashley Furniture.
Now this is where things get spicy, that double dip. The judge admits it himself, yes, she got the furniture and the money. In legal terms, that's unusual. But since Ashley Furniture didn't show up, the court had no choice but to side with the plaintiff. This is a perfect example of how fairness and legality don't always align. The company's absence left the judge's hands tied, turning what could have been a balanced resolution into a costly default. What do you think? Should the plaintiff keep both the cash and the couch?
Come here for me to put you under oath so she could ask questions to you about your ability to pay on this debt. Now, you're not an attorney, and I don't hold you to that standard, and neither is she. We're in small claims court, and the rules are more relaxed, but they still are the rules of civil procedure. The hearing you failed to appear for on March 10th, I placed Ms. Manley under oath on March 10th and asked her some questions. And she still wanted her $1,699. Failed to appear for this hearing, which was noticed for that day. Then I had a second hearing regarding the request to set the default aside, and I denied it. So you owe her $1,735.42. And she's here because she wants her money, plus $88 additional dollars for the additional service.
Here, the courtroom takes a detour into confusion. The judge is trying to piece together a puzzle of missed subpoenas, wrong jurisdictions, and service issues. It's a legal maze, subpoenas served to the wrong place, deputies delivering papers to the business instead of the person. For the audience, this is a crucial takeaway: in small claims court, technicalities matter. One misplaced notice can turn an honest mistake into a contempt hearing. This moment reveals how bureaucracy can make even a simple case feel like a marathon.
That you have some defenses you wish to raise. And I didn't enjoy entering this default judgment on March 10th, but you didn't show up. And then I had a hearing regarding why you didn't show up, and I didn't find good cause to find out why you didn't show up. So the ship sailed. You owe this money. Do you want to pay it, or do you want to get another $10,000 worth of bad publicity $1,735.42 plus 88.
Do I not get the furniture back, Your Honor?
No.
So she gets the furniture?
Yes, she gets a double dip because of your failure to appear for the hearing, which is what stopped. You prevailed. I took testimony. She was unhappy with what she got. She wanted to sue for even more. Ms. Manlin, do you have any other expenses other than the $88 service fee?
Just my loss of wages for all of my work missed.
That's not recoverable in small claims. Was there a filing fee for the subpoena or anything?
Just what I had on the paper already.
All right. $1,823.42. What was scheduled was a discovery hearing. And then her to discover your ability to pay on the debt. You're here, she's here, you're under oath. I don't find that you're in contempt for failing to appear for that subpoena. The officer just subpoenaed your store. And then I don't know what they did with it, put it in a desk drawer or something, but they didn't give it to you and nobody showed up. So I'll take you at face value that you didn't know about that hearing. Then I did this, that you specifically had to be here so we could all be in the same place at the same time. But in order for her to do that hearing, she paid an additional $88 to have a South Bend, St. Joe County, Indiana deputy serve you. So that's where we are. It's difficult to execute on an out-of-state judgment. If this were in Michigan, she could seize your assets. She could come.
We've hit the emotional core of the case. The defendant finally tries to explain, saying he thought things were made whole. But the judge shuts it down. You didn't show up. It's harsh, but it's the truth. Courts operate on action, not assumption. What's fascinating here is the judge's honesty. He admits he didn't like entering the default judgment. That's rare transparency. Still, law isn't about feelings, it's about process. Miss the process, you miss your chance.
To get everybody here. So the question is, are you willing to pay $1,824?
Again, Your Honor, she keeps the furniture. I pay her back for the furniture.
Yes.
And she's able to keep it. And
yes. I don't enjoy it. You didn't show up for the hearing. I took testimony. A default entered. She's still unhappy. She wants more than this. So I can't be any more clear. We had a hearing to set aside the default and I denied it. Yes, she gets the furniture and the money. So how does it, whether it's fair or not, that's how this came, because you didn't show up. So if you're not going to pay her the money, she can get an order to seize your property and fight it out that way. But,
may I ask another question?
Yes, sir.
And talking to my local attorney, he thought the jurisdiction would be in St. Joe County.
Jurisdictions at both ends.
Where you buy it? Because we have no stores in
yes, where she is and where you are. And it's a small claims case. The furniture was delivered to her in St. Joe County, Michigan.
Or picked up. I believe it was picked up.
A repair was sent to my house.
But the furniture was initially picked up in St. Joe County and at the store at the St. Joe County. I'm not an attorney. I don't understand.
I understand, but yes.
And our representative from Fort Wayne said he could not represent us in Michigan.
Well, and you can't have an attorney in small claims court. Right. You can remove it to the general division of the court where she would have had a harder time presenting it following the rules of procedure. All I want to know is, are you going to pay her the money or not? If you're not, then I encourage you to then get an order to seize property. You've got so much bad publicity about this, then it should really have just been resolved a long time ago. She's very diligent.
Your Honor, I thought it was resolved, so I apologize for that, and I Of course, paying, yeah, if you tell me where to send it, I will get it sent out.
All right, very good. Plaintiff will pay within 21 days. Her address is on the complaint and on the judgment. We'll give you a copy of that.
So I sent it to that address.
You sent it to her, not to the court. I understand that you feel this was unfair. She also feels it's unfair, so maybe there's enough.
And just like that, the case finally closes. Ashley Furniture must pay $1,824 within 21 days, the price of absence, confusion, and bad timing. Both parties leave feeling the sting of unfair fairness. This courtroom saga is more than just about furniture, it's about accountability. Whether you're a corporation or a consumer, showing up matters. Because in court, silence speaks louder than excuses. If you found this case as shocking as we did, hit that like button, share your thoughts below. Was justice truly served here? And subscribe for more jaw-dropping courtroom breakdowns every week.